Ready? Start. The present appeal has been preferred against the judgment dated 19/5/2025 passed by the High Court of Uttarakhand wherein, an issue with respect to the scope and applicability of the first proviso to section 223 in bracket 1 of the Bharatiya Nagrik Suraksha Sanhita, 2023 in bracket hereinafter referred to as the double inverted comma open BNSS double inverted comma close bracket close had arisen, while dealing with a case where the prosecution complaint under the Prevention of Money Laundering Act, 2002 in bracket hereinafter referred to as the double inverted comma open PMLA double inverted comma close bracket close had been filed prior to the date of commencement of the BNSS full stop para. An ECIR was registered by the respondent against the appellant, being ECIR oblique DNSZO oblique 04 oblique 2023 on 24/7/2023, pursuant to which he was arrested on 27/4/2024, full stop. Within 2 months from the date of the arrest, a prosecution complaint was duly filed by the respondent on 24/6/2024, invoking sections 44 and 45 of the PMLA for the offences under section 3, read with section 4 of the PMLA before the designated special court, full stop. On the very same day, the special court issued a direction to register the complaint so filed as a miscellaneous case and, thus, fixed it for hearing on cognizance on 28/6/2024, full stop para. When the case came up for hearing on the said date, it was once again fixed for hearing on cognizance on 2/7/2024, since the presiding officer was on recess, full stop. On behalf of the respondent, the learned special public prosecutor had appeared, and the appellant was produced from judicial custody through video conferencing, full stop. Within a few days thereafter, the erstwhile Code of Criminal Procedure, 1973, in bracket hereinafter referred to as the double inverted comma open CRPC double inverted comma close bracket close was replaced by the BNSS with effect from 1/7/2024, full stop. When the case came up for hearing on 2/7/2024, the special court took cognizance of the offence in the presence of the learned special public prosecutor and the legal advisor who had appeared on behalf of the respondent, and the appellant, who was once again produced in judicial custody from the district jail, full stop. The miscellaneous case registered earlier was re-registered as a special sessions trial number 28 of 2024, full stop para. The following is the conclusion arrived at by the special court upon taking cognizance, para. From the perusal of the complaint, it is clear that in the present case, sufficient material is available to take, cognizance of Section 3 read with Section 4 of the Prevention of Money Laundering Act against the accused Parvinder Singh full stop. Accordingly, cognizance is taken of Section 3 read with Section 4 of the Prevention of Money Laundering Act against the accused Parvinder Singh full stop para. An application for recall of the order dated 2/7/2024 was filed before the Learned Special Court on 24/12/2024, inter alia, alleging that the mandate of Section 223 of the BNSS, with specific reference to the first proviso to subsection 1 had not been compiled with, as the appellant was not given an opportunity of hearing before the special court while taking cognizance, full stop. The said application was dismissed by a special court, wide order dated 22/3/2025, holding that the filing of the application was merely a dilatory tactic employed by the appellant and that once cognizance had been taken, the same court cannot reconsider it, full stop. Further, the special court, wide the said order, also framed the charges against the appellant under Section 3 read with Section 4 of the PMLA and put up the case for recording of prosecution evidence on 5/4/2025, full stop.